However, there are certain caveats, which we're kind of go off on a tangent, but under the statute, you have to receive a certified copy of the transcript. The child has to be enrolled in at least 15 hours or be enrolled part-time and work 10 hours per week. So depending upon what the factors are, the court could emancipate the child, or you could still be on the hook for child support. So if your child is 19, 20 years old, is it worth going in and incurring the litigation costs and filing the motion to modify? Because one, you could be potentially liable for an increase in child support, but also even if you are successful on your motion, are you saving money? Because you want to do a cost analysis to benefit what could it potentially cost on the legal fee side versus what are you going to save on the child support side if indeed it is modified and decreased.
So again, you want to be sure to be doing everything above the board and with the court's knowledge of it. So you want this to be something that if you're going to go to modify your child support, it needs to go before the court, and then you need someone experienced, an attorney who will be able to help you decide if what you risk by entering the courtroom.
Absolutely. I mean, you don't want to hire an attorney who's not experienced in dealing with the child support modification, because you could potentially incur a substantial amount of litigation costs, increase in child support, and you could potentially be exposed to a portion of your ex-wife's attorney's fees.
Okay, and another thing too is that I wanted to bring up, because we get a lot of this. A lot of people are writing in, both men and women, and saying that they have a responsibility, a child support responsibility, but they themselves have started another family. The fact that you have decided to have more kids, in your new marriage, doesn't affect the responsibility that you have to the kids that you're already paying support for. Is that correct?
Basically, I mean, a court may take that into consideration, but that factor alone is not going to help you out in decreasing your child support payments, because the court's not going to penalize the child from your prior marriage just because you've moved on and you're having additional children.
Okay. All right. Well, the second one ties into the economy a little bit, and it also deals with child support payments. And Ben from Missouri writes in and he says, "My question is that my wife and I are separated. We signed a separation agreement in November, and in the agreement I agreed to pay her $1,000 per month for child support. And I've been giving her that amount since August, when she made me move out. The divorce is not yet final." He says, "However, recently he was laid off from work, and he's currently seeking employment, but in the meantime he's going to try to draw unemployment. And he says there's no way that he can continue to give her the amount that they agreed in their separation agreement, which was $1,000 a month. He says that his last paycheck will be coming the 1st of January. So as of right now, he's just received his last paycheck, and he's asking what advice you would give. Where can he go from here?"
Well, my first question is, when he's using separation agreement, that's not a final agreement signed by the court. Maybe if he's referring to what's called a penente lite motion or a PDL motion, which is a temporary order signed by the judge, which can deal with a variety of issues, and in this particular case, it could be dealing with visitation and child support. And if that's the case, then he's going to go into court and file a motion to amend this particular agreement that is referenced, because the fact that he has lost his job, that the court can use that to modify the child support. Now, one thing that wasn't mentioned in there, and depending upon what the circumstances were of the layoff, if it was performance related, did he quit and they just laid him off? So those are some factors that I would like to know as his attorney. What were the circumstances surrounding his basically discharge from the employment? If it was just due to the economy and the fact that they were laying off people, then he can go into court and petition the judge to lower the child support based upon a current salary, which unfortunately in this case he's not working, but he's still going to be liable for it to support the child, but the court won't impute a higher income to him as he was earning.
So what happens in general when a when a person who's expected to be paying child support, what happens when they lose their job and there's no money coming in, and let's say that they go for several months without a paycheck? Is there any kind of emergency thing that they can do to to, just so that they're not held in contempt or something like that? Or
well, if once you have lost your job and you're not receiving income, what you're going to want to do is file a motion to modify the child support payments. And in that particular motion, you allege the substantial continuing change is the fact that here's the order that you were underneath, here's the income that you were receiving at the time that the order was entered for child support. You're no longer employed through no fault of your own, and here's either the new income that you're receiving, which is less, or the income that you're not receiving because of the layoff. And you're petitioning the court to lower or modify the child support based upon your current circumstances. And also what you want to include in one of the accounts in the motion is you want the court to apply that retroactive. Because if you lose your job starting January 1st and you are, January, February, March, you do 5 months of non-payment of child support, and then you file a motion in May, well, the court can only go back to May when you file if you ask for it to be applied retroactively. The court will not modify from January to...
I see.
But the court will not find you contempt as well. Because the fact that even though if you haven't filed the motion, you still are under a court order, which is enforceable. And if you're not paying the current amount, which in this case is $1,000, then you could be subjecting yourself to a contempt of court. And you don't want to be found in contempt of court.
Well, let me ask you one more question based on this question from Ben. He said that when he and his wife separated that they signed a separation agreement. Now, I know that we don't know exactly what type of agreement that is, and you mentioned one that was sanctioned by the courts. But are there different types of separation agreements? Are these? Is it possible that he and his wife just came up with an agreement and signed it? Is that admissible?
I mean, if he and his wife came up with a verbal agreement and there's nothing signed by the court, then technically or legally it's unenforceable. However, you could present evidence of the fact that there is this verbal agreement, here's what the agreement is, and here's the pattern or the precedent that has been set pursuant to this agreement. And if the agreement was just a verbal agreement for the $1,000, and you can establish, month after month after month that $1,000 has been paid, then the court could find the fact that there was an agreement between the two parties and enforce that. But on its face alone, if there's no document filed with the court and signed by a judge, then that in and of itself is unenforceable.
Okay. One more question, and this one comes from Gary in Kansas. He says that his wife was in an accident and she's going to receive payment for lost wages and reimbursement for rental car. They're still married. This is while the vehicle is repaired. She was not injured in the accident. He and his wife are currently separated. And the first divorce hearing is at least a month away. And he is asking if he's entitled, because they're still married and this accident happened while they were married, is he entitled to half of the insurance payment? And he says he really doesn't necessarily want the money, but he'd like to possibly use that as a tool when he negotiates. And he'd like to use that to pay down their debts.
Sure, absolutely. And we come across this every now and then. And it's really going to be determined how the settlement is structured. And if the wife is receiving monies for a rental expense and lost wages, well then, yes, he's entitled to half of that or a percentage of that because wages are considered marital property as well as the rental expense. Now, if she's receiving any monies for any injuries that she has received, then he may not be entitled to that. So if the settlement is structured in a generic way where she's receiving X amount and that'll cover, lost wages and whatever else, then there's an argument that he's entitled to a percentage of that. But if the settlement is structured where it specifically states that she is to be paid out a certain amount of money for the injuries that she has received, pain and suffering, then no, he's not going to be entitled to that. So in order to kind of be proactive, I don't know if an attorney has been hired on the personal injury suit, but I would try to get the settlement to be structured in a way that it's not just for pain and suffering, because that takes it out of marital property and puts it in separate property, and then the wife has 100% of that money right there, and unfortunately this guy will not be able to have any access to it.
Okay. All right, well, that's all we have time for today. We'd like to thank you for tuning in and remind you to log in to DadsDivorce.com, and if you have questions, submit them to our Ask a Lawyer area. That's under Resources. Again, for Dad's Divorce, my name is Rick Ortiz, and we were joined with Dan Cuneo from Cordell and Cordell PC. Thank you.
Thank you.